Lawyers are among the professions that benefit most from AI tools. In drafting, reviewing, researching, and analyzing large volumes of documents, the productivity gain is real and significant. However, even the most sophisticated AI tools hallucinate. They produce fundamental errors, not occasionally and not randomly, but as a structural consequence of how they work. It is therefore essential to understand these risks and develop a principled approach to managing them without sacrificing the benefits AI delivers. This presentation outlines the typical errors AI tools make and explains their technical rationale, including why this problem persists across all tools, including the most advanced. It explains why these errors are particularly difficult for lawyers to detect, and it proposes a risk-based governance model that preserves the benefits of AI while keeping risk at an acceptable, defensible level. As lawyers grow more confident with AI tools, a new risk emerges: overconfidence. This presentation addresses that risk. I keep the scope deliberately narrow. We focus on AI errors and how to manage them. Other topics such as confidentiality, intellectual property, and data privacy are covered separately. So we have two objectives. First, to create awareness of the structural error risks inherent in any AI tool, free or paid, general or legal specific. Second, provide a practical governance model that captures the efficiency gains while keeping risks defensible. The framework presented here has been developed independently, but is mainly consistent with ABA Formal Opinion 512 on generative AI tools, published in July 2024. Where relevant, I will flag the connection explicitly and highlight deviations. So, first thing is we should not humanize AI. I'll give you an example. When we supervise a junior lawyer, we build trust over time. So we observe recurring strengths and weaknesses, adjust our oversight accordingly, and over time, if performance is consistently strong, we review less closely. This works well because human learning is cumulative, and past performance is a meaningful predictor of future reliability. So it is entirely natural that we apply the same logic to AI tools. If I deliver strong outputs repeatedly, so our confidence increases and our review intensity drops. So as I will show you next, this is structurally incorrect and potentially dangerous. AI can produce sophisticated legal analysis and at the same time completely fabricate that case law it cites. That is not a quality issue of a particular tool, it is architectural. So to summarize it, fluency of output is not an indicator for correctness. So the reason that a human's trust model fails for AI comes down to 5 structural characteristics. AI work different from humans. So humans know and apply the law. They take a logical approach where the same input leads each time to the same output. AI, on the other hand, generates its outcomes according to probability, and these can vary. Humans can verify the correctness of their assessment in legal books or court decisions. AI can only assess if the result is the most likely outcome. Humans learn. Past error-free performance is a good indicator for the quality of future work. For each AI query is a new task. So past error-free performance is not an indicator for future performance. A very important thing is that human professionals make typically no mistakes in core teams, but they may make errors in subordinate areas. AI errors, on the other hand, are non-systematic. They can occur in core and peripheral areas alike. Last but not least, sloppy work of humans can often be recognized in formal mistakes, spelling errors, wrong numberings, or citations. AI work always looks perfect, even if it's completely wrong. So let's come to the categories of AI errors. So not all errors are equally difficult to manage. Some follow recognizable patterns, and those are the easier ones. Taking the example of comparing supplier contract against your template. AI may miss an internal reference to the law at the place of residence of a party, so they need to look up there where the party place is. Or they may fail to properly evaluate an external reference, let's say the UNCITRAL rules of arbitration, which are not incorporated by reference but need to be looked up and need to be found there. Another classic is silence on a topic in a contract. This is sometimes very significant. Let's say under Swiss law, if there's no liability clause, then the parties are unlimited liable under the Swiss Code of Obligations. AI may not reliably flag and understand that consequence. So these are the manageable risks. An experienced lawyer can build targeted checklists of the usual suspects and apply a structured review to catch them. More serious and more difficult are the non-systematic errors, which are commonly called hallucinations. In legal work, hallucinations go far beyond simply making things up, because they include fabricated content, so invented case law or non-existent statutory clauses. Further, this could be false positives or false negatives, so AI may miss an actual deviation in a contract review or flag a deviation that does not exist at all. It could be logical slips. So a correct clause by clause analysis could then be followed by a legal conclusion that is completely unsupported. And last but not least, there could be material omissions. For reasons unknown, a critical gap in a contract is simply just not spotted. So the defining characteristic of these errors is that they follow no pattern. That is why it makes them so dangerous. Because they are non-systematic, a structured spot checks are not a reliable control mechanism. You cannot build a checklist for what you cannot anticipate. Model drift. This is a risk a little bit less known, but still real or still important. AI tools are not static. They are updated continuously. You don't even notice it. So new models versions are released every other day. Safety layers may be adjusted and training data changes. And even if you're in a company, enterprise configurations may be modified in the back. So the consequence is that a prompt chain or a workflow that performed reliably in January may produce a completely different result in June without any visible notice to the user. Unlike a trained lawyer whose competence stabilizes over time, AI systems offer no behavioral stability guarantee. So, the $1,000 question, how do we capture the benefits of AI without exposing ourselves to unacceptable risk? The answer is a risk-based approach to human review, anchored in one key question. Is an elementary mistake in a material aspect of this deliverable tolerable or not? So if the answer is no, and this will typically be true for materials that go to the client, to courts, regulatory filings, and so on, board materials, etc. A full human verification of the deliverable is required. Spot checks are not sufficient because non-systematic errors can occur anywhere. If there is a limited tolerance, let's say internal drafts, some preparation materials, or early stage analysis, then we should undertake a structured validation of the core elements. So look at what is key and only at what is key. If the impact is low, let's say for brainstorming documents or formatting exercises, then a cursory review for obvious flaws is enough. And the critical point I want to stress is that this must be a conscious, explicit decision in each case. So not a default and not something that happens by habit or coincidence. It must be a deliberate judgment call made for each matter. The formal opinion 512 of the American Bar Association states as well that the appropriate level of verification depends on the specific tool and task. However, the ABA in this opinion notes that prior testing of a tool may justify reduced verification for comparable subsequent tasks. I tend to disagree. As you have seen earlier in this presentation, reliance on positive early work is only justified to a very limited extent. So it relates to predictable error patterns, but it says absolutely nothing about non-systematic hallucinations. They can occur each and every time, even if they have not occurred in the past. Furthermore, models might change over time and perform tasks different than today than 6 months ago. So I would not say that past performance is an indicator of future performance. Client transparency, that's a delicate topic. So let me be very precise. The starting point is crystal clear. Lawyers remain fully accountable for their work product, regardless of whether it was created or reviewed with AI assistance. Period. The standard for lawyers is also clear. Full human verification of products that are sent to the client or to the court or to the regulator. This is a consequence of the basic obligation of a lawyer to competently represent his clients. If a full human review has been done, then there is, in my view, no obligation to disclose the extent of AI involvement to the client. Transparency about AI use is not a general requirement. It is a specific exception, triggered only when full human review was not performed. And that exception arises when time or cost constraints make it appropriate and actually in the client's best interest to rely on AI output without complete human re-verification. In those cases, and only in those cases, the residual risk must be made explicit to the client and his acceptance obtained and documented. So that means, well, what does that mean, this documentation? That means communicating the scope of the AI involvement, what was and what was not independently verified, the residual risk and what the potential worst case consequence could be, and what full human verification would cost and time and effort. Now, documentation has always two sides, and on the one side, this is important for governance and audit purposes, but it also must be prepared with privilege principles in mind and with the awareness that this could be surfaced in litigation. So this must be done very carefully. And just for summarizing, this is not an admission of unreliability on behalf of the lawyer, but the evidence of structured professional risk management. The ABA opinion requires, in addition, transparency where AI output materially influences a significant decision in the representation. They name reliance on AI to evaluate litigation outcomes, guide jury selection. In that situation, disclosure shall be required regardless of whether AI work was reviewed by humans or not. As an in-house counsel, I am less confronted with this question and I have no personal view on that. So just to close it, full human review has been performed. There is no need to disclose the AI involvement. End of story. So the model here is the exception, not the rule. Let me summarize it. Firstly, AI materially increases legal productivity and the quality of legal work, so it shall be used by every lawyer as much as possible. The risks of this outlined in this presentation are therefore clearly not a reason to discourage the use of AI. They are a reason to use it thoughtfully. The core insight is this: elementary errors can and will occur in absolutely crucial aspects of any work product. And this applies to free, premium, and specialized AI models alike, and I have no view of the future, no glass ball to say it, but I don't expect, because this is an architectural issue, I don't expect this to change in the foreseeable future. These errors follow no pattern, so therefore they cannot be reliability caught by any spot checks. So responsible use therefore means applying a risk-based review model calibrated to the tolerability of error in each specific matter. And as the opening quote puts it, a danger known is a danger avoided. Thanks for watching. See you soon. Oh, something I almost forgot. There is this slide deck. I have made some checklists with this for the decision tree as well as for the transparency model, as well as other AI materials. which you can find and download on my website on the link as you can see below. Thank you again and see you soon. Bye bye.